You'll just email the attachments to the clerk. Good morning, you're Ray No,
Good morning, ma'am. Yes, ma'am.
and will your client waive the formal reading of the indictment in each case?
He does, Your Honor.
Just a second. Figure out what today is. Sorry, I'm getting there. Mr. No, in cause number 25, DCCR 0386, you're charged with the second-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And how do you plead to that charge?
Whoa, guilty to intoxication manslaughter? That's not just a DUI, that's a life lost. And the judge just noticed something critical. The charge is marked aggravated. Why? Because a vehicle was involved, which in Texas can bump this from a second-degree felony to something even worse. But the judge is already marking it out. Why? Is she giving him a break or setting up a harsher sentence later?
Guilty.
And y'all have marked here aggravated. What is,
Defense counsel put that here.
Yeah, well, they charged it as aggravated with a vehicle, I believe. It's aggravated.
It's just a garden variety cops.
yeah, I'm gonna mark that out because I think that might have some
Different context.
context at sentencing that you may not want. All right, so it's, how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
You're charged with a trial.
Sorry, give me just a second to get to the other one. And then in cause number 25, DCCR 0387,
A second felony, driving drunk with a child in the car. That's not just reckless, it's a one-way ticket to a judge's bad side, and he's pleading guilty again. This guy is either the most remorseful person in Texas, or he's about to face a sentencing hearing that'll make your jaw drop. Stick around, this is far from over.
you're charged with the state jail felony offense of driving while intoxicated with a child passenger from December 11th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they've charged you with?
Yes, Your Honor.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Franklin?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand that it's first of all, it's the way this is written up is that you are pleading open to the court. There's no agreement. Is that correct?
Yes, Your Honor.
And so you guys, a couple things. I need the other one sent back. So is it on the trial court certification of defendant's right to appeal? On this case, the state jail, the admonishments were signed saying that they're waiving the right to appeal, and then on the certification, it's actually 2 of them were checked off. One is the defendant has waived the right of appeal, and the other is it's not a plea agreement and the defendant has the right to appeal.
It's not a plea agreement.
Right.
So that's correct.
Okay, so with everyone's permission, then I'm going to erase these check mark on the defendant has waived the right of appeal because it's not a plea, so he will have some right to appeal.
Yes, Your Honor.
No objection.
Also, on each of the paperworks on the post-conviction waivers that you both signed, I will mark that out as well because that's saying that he's waiving his right to appeal.
Yes, Your Honor.
Okay, all right, thanks. So,
Your Honor, I would note too, I think I had a few stray, I'm a left-hander. I think there's a few other stray marks on there that
Okay.
I tried to erase and wasn't able to. So
Gotcha.
if you see those, I apologize.
gotcha.
my hand.
We understand the left-handed issues up here. Ms. Werner feels your pain on that. Okay, so I want to make sure you understand a couple of things. You have an absolute right to have a jury come in and determine.
Judge just laid it out. He's giving up his right to a jury trial and letting her decide his fate. That's a gamble, because judges don't have to be beyond a reasonable doubt convinced. They just have to be convinced. And with 2 guilty pleas already, do you think she's in a forgiving mood? I wouldn't bet on it.
Determine 2 things in these cases. The first would be to determine if you're guilty or not. And then the second would be if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving your punishment up to me in each of these cases. And is that what you want to do?
Yes, Your Honor.
All right, state tenders number 1 in each case.
No objection, Your Honor.
It's admitted. Also, sir, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
All right. Is there any evidence that Mr. No is not competent?
No, Your Honor.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence to find you guilty. However, I'm going to reset your cases for a sentencing hearing so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Obviously, if there's anything important that you want me to know, get that information to Mr. Franklin. He will present it to me on your behalf when we come back. Do you guys anticipate a little bit of extra time on this one as far as witnesses or argument,
Just brief, not much,
but a little more than normal?
Yes, Your Honor.
Okay, so if I were to set it at 11 on a docket date, we could, maybe an hour would be enough, or do you
Yes,
think
Your
we
Honor.
need?
I think an hour.
Okay, all right, so we'll reset it for sentencing and we'll just do it at the end of a docket so you don't have to sit and wait unless you have some other cases. You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right over there. All right, we'll see y'all back at sentencing. Thank you.
Thank you, Judge.
On Mr. Boyd?
yes, ma'am.
Okay. Is it
It's a
a?
rejection.
Okay. Good morning, sir. Are you David Alexander Boyd? And Mr. Boyd, in cause number 25, DCCR 0720, you're charged with the 3rd-degree felony offense of deadly conduct, discharging a firearm from March 20th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand?
Yes, Your Honor.
And I'm going to get a plea bargain rejection. What is
10 years probation for deadly conduct, discharging a firearm. That's actually a good deal in Texas, where this charge can land you 2 to 10 years in prison. But this guy is rejecting it. Either he's got a killer defense, or he's about to learn the hard way why you don't roll the dice with a Texas judge. What would you do?
the offer?
The state's offering 10 years, probated for 10 years with a $2,500 fine. Standard conditions and no contact with a couple of complainants, as well as stay away from the Little Woodrow's establishment.
Sir,
Yes.
spit whatever is in your mouth out in that trash can over there. So you've signed a plea bargain rejection with your attorney, Mr. Jeffries, and it's going to show 10 over 10, right?
That's right.
So it's for, if you wanted to enter a plea of guilty for a 10-year term in prison, that would be probated. You'd be on probation for 10 years. You would be ordered to pay a $2,500 fine to follow all of the rules and conditions of probation. You have every right to reject that and have your case set for trial. I want to make sure you understand today what your options are if you wanted to plead guilty and what your possible consequences are if you go to trial and are found guilty. Do you understand all of that?
Yes, Your Honor.
And do you want to reject that offer and have your case set for trial?
Yes, Your Honor.
All right, we'll get it set for trial. Mr. Coleman, is there any reason to believe that that offer would change?
Not at all, Judge.
So, Mr. Boyd, I want to make sure you understand that after today, I don't accept plea agreements once they're rejected.
The judge just dropped the hammer. If you reject this, there's no going back. That's not a warning, that's a promise. And with the DA saying the offer won't change, this guy is betting his future on a trial. But here's the kicker. If he loses, he's looking at prison time, not probation. Is this confidence or catastrophe?
So unless new information comes to light with your attorney or the district attorney's office, then if you change your mind later and want to enter a plea of guilty, it would be to something different than this or open to the court. Do you understand?
Yes, Your Honor.
All right, then we'll get your case set for trial and Mr. Jeffries will begin preparation. And if y'all will just send that through, I'll
Just see.
sign off on it. Okay, perfect. You're free to go, sir.
In today's court session, several defendants addressed their charges.
2 guilty pleas, a rejected deal, and a trial on the horizon. Today's court was a masterclass in high-stakes decisions. But here's the question. Who made the smartest move? The guy who pleaded guilty and hopes for mercy, or the one rolling the dice at trial? Drop a comment. Who do you think is walking away with the best outcome?
And pleas. Mr. No pled guilty to intoxication, manslaughter, and driving, while intoxicated with a child passenger, freely and voluntarily, and his cases were reset for sentencing. After pre-sentence reports are prepared, Mr. David Alexander Boyd rejected a plea offer of 10 years probation with a fine, and will proceed to trial for deadly conduct by discharging a firearm. Mr. Larry Fletcher's motion to revoke probation and his new cases of manslaughter and aggravated assault were reset for sentencing in 45 to 60 days to handle all matters efficiently. Ms. Dale Johnson's cases were also reset for trial after her defense requested extra time due to an unavailable expert. The court emphasized that all defendants understood their rights, the consequences of pleas or trial, and that these decisions carry lasting impacts on their futures.